If you own a business and you want to set up a trust to own that business, there's a few things that you need to know before you do, especially if you plan on being a trustee or a beneficiary. I'm Ted Sutton, and this is Direct Answers from Corporate Direct. Now, before we get started, please make sure to like, subscribe, and leave a comment if you have any general questions about anything. Today's video topic comes to us from John Gatlin, because he commented on one of my videos. And the question John asked is, what if I have a trust and it owned a C Corp and I was the beneficiary of the trust? Thanks, John. Well, first of all, if you own an interest in a corporation, there's a few things that you need to know. One of the benefits of setting up a C Corp is that there's a lot of ownership flexibility for who can own it. A C Corp can be owned by an individual, it can be owned by another entity like a C Corp, an LLC, or a limited partnership. And also, C Corps can also be owned by trusts. However, the biggest downside with setting up a C Corp is that you face the double taxation. This is where you face one tax at the entity level and another tax at the individual level. I did another video on the differences between C Corps and S Corps, and if you want to watch it, click the link in the description below. In some situations, owning a C Corp may be right for you, but definitely double check with an attorney or an accountant for specific advice to your specific situation. Now, let's talk a little bit about trusts. A trust is a three-party arrangement where you have a grantor, a trustee, and a beneficiary. The grantor is the person who sets up the trust and deposits assets into it. The trustee is the person who manages the trust for the benefit of the beneficiaries. And the beneficiaries are the people who receive the benefit of the trust. There's some states out there that allow one person to play all three roles. And in these states, you're allowed to set up what we call self-settled asset protection trusts. However, it's best practice to have a second person be the trustee. If you have a second person be the trustee, the trust appears to be more valid and less fraudulent. This is especially true if you set up the trust and you're a beneficiary of the trust. Let's talk a little bit about what trusts can own. Most trusts can own an interest in a C Corp, an LLC, or a limited partnership. However, in some circumstances, trusts can own interests in an S Corp. But in order to do so, there's some requirements that need to be met. There are two different types of trusts that can own an interest in an S Corp. One is called the Qualified Small Business Trust, or QSBT for short, and the other one is the Electing Small Business Trust, or ESBT for short. You can set up these trusts by filing Form 2553 with the IRS, but make sure to go to an accountant first before you do. You can set up these trusts by filing Form 2553 with the IRS, but definitely go see an accountant before you do. If you own a corporation and you want to set up a trust to own your interest in that corporation, it's certainly doable. However, it's best practice to have a second person be the trustee, especially if you're the beneficiary of that trust. On top of that, it's best to go to an attorney and an accountant for more specific advice on your specific situation. I'll see you next time. Hold on, I'm not done yet. If you're looking to start a business, click the link in the description below and schedule a free 15-minute consultation with us. Also, make sure to check out the Corporate Direct website and subscribe to our newsletter, where we'll send you a lot of good information on corporate law amongst other things. And as always, make sure to like, subscribe, and leave a comment if you have any general questions about anything. I'll see you next time.